next case is State of Ohio, City of Akron versus Anthony Irvin. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. Please let me know if you plan to reserve time. The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the names of children, minors, or victims in your argument. Please refer to them by initials or terms like the child. We have read your briefs and are ready to proceed when you are.
Thank you, Your Honors. May it please the Court. Andrew Karras on behalf of appellant defendant Anthony Irvin. I would ask to reserve 4 minutes of my time for rebuttal. This case, we have raised 3 assignments of error, really 2 sets of issues. The first is an evidentiary one. The second set of assignments of error relates to sufficiency and weight. I'm going to start with the hearsay and confrontation issues. In this case, responding police officers, their body camera footage was admitted. One of those exhibits, the trial court redacted statements by non-testifying witnesses. The other, while a nearly identical objection was made, the objection to the admission of the complainants in the case were overruled. And so, importantly, what got admitted as a result of the admission of Exhibit 1 was a statement by the person who apparently made the dispatch call that Irvin had been fighting prior to the officer's arrival. That was evidence that appears to have mattered a considerable amount to the trial court when it rendered its verdict. We do have a recitation of reasons for the verdict that was given, and the trial court does mention that the officers responding to a fighting call. There was talk of fighting that was going on before the officer's arrival.
Is that hearsay though? Because is it made for the truth of the matter asserted, or is it to maybe describe why the officers were there in the first place?
So I think it is offered for the truth value. One, because per the terms of the state's closing argument and per the terms of the state's Rule 29 argument, the state's theory was that Irvin was fighting before the officers arrived. And so it was, I submit, offered as substantive proof of that, and the trial court, at least in some measure, indicated that it was thinking about that evidence as substantive proof of the fighting element of the disorderly conduct statute. The state hasn't at least fleshed out a kind of Ohio versus Rick's argument about circumstances where statements that are explanatory for officers' conduct can be admitted. I submit they couldn't because, among other things, the statement does tend to identify Irving as the perpetrator of the crime, and so it wouldn't meet the Rick's standard.
He could be the perpetrator of the crime without being the perpetrator of the initial fighting, though, right? Well, the charge he's convicted of here is the disorderly conduct, right?
Correct.
Okay. So he could be disorderly in the way he interacted with the police and the way he interacted with the people that had called and reported the situation without being the perpetrator of the initial fight. He could still be guilty of being a perpetrator without being a perpetrator of the initial fight.
So, not pursuant to the statement that was admitted, I think the statement that we're taking issue with, identifies Irving as the perpetrator of a fight, and I don't think the statement was explanatory of the officer's conduct in finding Irvin. He was across the street; they knew where he was at this point. I think the statement was also testimonial. The test there is whether it was made under circumstances that would lead an objective witness to believe that the
You're
statement.
just talking about the initial. I was going on the basis of you saying the officers kept referring to him as the perpetrator, and that doesn't mean that he was the perpetrator of the fight. Is what I'm trying to get at. But regardless of that, so what you're talking about is the only statement that you're concerned about is the initial statement on the police call. 911 call?
So not on the dispatch call itself, the statement made to the officer, once he comes onto the porch at the Morning View home, talks to the woman, and she says, among other things, that he was fighting.
Right, so you have the 911 call that says there's a fight going on.
Mhm.
Okay, and then the officers arrive, and whenever they approach the complaining party, the person that made the 911 call, she says that Irvin was engaged in fighting behavior with them.
Correct, that's the summary of the evidence is there. I hope I've answered your question.
Yeah, it does. I just
And-
wanted to make sure what you were actually complaining about.
Correct, and the dispatch call for, just to be clear, was not admitted into evidence. There are two exhibits. They are, 1 and 2, the respective body-worn camera footage of the responding officers. And to the extent you were kind of getting at prejudice, wasn't there other evidence of fighting? I submit that the answer is actually no. There's certainly my client's statement that he had been assaulted, but that's not evidence that he had been in a fight. The trial court, for better or worse, did seem to rely on the fact that there was a fight before the on-camera fracas kind of started.
There's nothing in the disorderly conduct that requires there to be an actual fight, right?
No, there is not. But the test for harmlessness is whether there was no prejudice, whether the admission of the offensive evidence is harmless beyond a reasonable doubt, and whether excising that evidence from the record, you can say beyond a reasonable doubt that the remaining evidence demonstrates guilt. So, in this circumstance, where the trial court does sort of just explain his decision, and that includes, among other things, a reliance on the idea that there had been this fight prior to the officer's arrival, I don't think it is harmless beyond a reasonable doubt.
Do you think the remaining evidence outside of this comment that he was engaged in fighting prior to the officer's arrival is sufficient, given as the trial court pointed out, the hour of the day, the fact this is a residential neighborhood? I know that he is across the street from some other individuals, but there seems to be a ruckus about. Do you think that that's sufficient for disorderly conduct?
At this point, maybe pivoting to the second assignment of error. So I think there are a couple of reasons there's not sufficient evidence, and we frame this both in sufficiency and weight terms, but it's worth breaking the disorderly conduct, here the ordinance, but it tracks the language of the Ohio Revised Code into kind of its two separate components. So the first sentence is that no one shall recklessly cause inconvenience, annoyance, or alarm. That is, it requires proof of a subjective mental state on the part of the victim.
I thought that was interesting. Are you saying there's case law that says the officer can never be the one
So
who subjectively has the annoyance, alarm, or...
So there are cases that distinguish between whether an officer can be a victim in his official capacity versus his personal capacity. I think you don't necessarily need to get into that on this record, where the officer's testimony was, we didn't regard our response to this as out of the ordinary. We didn't, in effect, saying we didn't find this annoying or alarming or inconveniencing.
I see. You're saying even if we assume that they could be in this capacity, that testimony wasn't there.
That's correct, Your Honor.
What about, it's interesting that some of the video was played without sound,
Correct.
so it was just people gesturing and...
Yes.
Is it gesturing evidence, like if they look in a way?
So, just as a basic tenet of law, I mean, circumstantial evidence can be proof of an element. Here on this record, I don't know that the gesticulations, in and of themselves, meet the element of demonstrating that they are annoyed, inconvenienced, alarmed. And I think, maybe what's kind of illustrative here is maybe the most principally relied upon case in the state's brief, that's the Salmon case out of the 8th District, is it's a voluntary intoxication disorderly conduct offense. That is, it's subsection B of the statute, which, by its terms, doesn't require, like subsection A, proof of a victim's subjective mental state. So the language in Salmon is that you are required to provide proof of that an offender engages in conduct likely to be offensive or cause inconvenience. So there is a difference, I think, between subsection A and B of the disorderly conduct statutes in terms of what kind of proof is required. But to maybe, Your Honors, turn back to your original question, because I did want to get the subjective component on the part of the victim of the statute. I did want to address that, but to speak to kind of the more objective part that has to deal with the offender's conduct, there also has to be proof that the offender engages in fighting, in threatening harm to persons or property, or in violent or turbulent behavior. As we've laid out in our brief, as I've laid out before, there's no evidence of fighting certainly once the officers arrive on the scene. I mean, there are no fights. Any evidence of that fighting pre-arrival, again, is hearsay. And to be candid, the worst fact I think we have to deal with are there are some statements on the part of my client, to the effect of, well, you're going to get it, we'll see. And what I would just say is putting those statements into the context, looking at the record in full. Irvin was agitated, and so there's those statements that you could putatively regard as threatening were the product of his agitation. He was being egged on. They're not something that could or should be objectively understood as an actual threat.
You're running into your rebuttal time.
Yeah, let me just ask you really quickly. So 2 questions. One, it doesn't really matter in regard to sufficiency of evidence because we have to consider even inadmissible evidence for sufficiency, right? So if you consider the inadmissible, what you're saying is inadmissible evidence about a fight occurring, that would obviously be sufficient evidence.
So sure, that to the extent our argument is that there was no evidence of fighting that is, in that sense, dependent on you not overruling our first assignment of error.
But my point is for sufficiency. Okay, for sufficiency. Okay, then in regard to the sufficiency of the evidence as well, or actually the admissibility evidence, what about the fact that this is a bench trial?
So it is true that you generally presume that trial courts, even when they hear improperly admitted evidence, can attach the appropriate weight. Indeed, the trial court said something to that effect in overruling Irving's objection. But what you do have here is an on-the-record recitation.
But does the trial court actually say, I relied on the fighting, or does he relate how the call came about?
So does he say there was a fight before we got here because he was using that as substantive element for proof of the offense in part, or was he sort of using it for those kind of setting the background investigatory purposes? He doesn't explicitly break it out in that sense, but given the harmlessness standard and given the fact that fighting in a general sense was important to him, I don't think you can say that the admission was harmless. And with that, I would reserve my remaining 2 minutes. Thank you.
Again, Your Honors, good morning. I'm Jacqueline Corgan on behalf of the City of Akron. May it please the Court, I represent the appellee. And the City asks this Court respectfully to affirm. Regarding the woman in red on the porch, whose statements were, to the extent they were intelligible, were given to Officer McDowell, her statements are a red herring in this case, because nothing in the record indicates or even insinuates, no reasonable reading of anything in the record, it indicates or insinuates that Mr. Irvin's arrest, his charge, his prosecution, or his conviction depended upon anything that that woman in red said on the porch to officers. Everything in the record leads instead inexorably to one conclusion, and that is that the conduct for which Mr. Irvin was arrested and charged and prosecuted and convicted was all the conduct that he engaged in not just in presence of Officers McDowell and Officer Hughes, but on their body-worn cameras that was recorded. And for an indication of that, I would refer the court to the prosecutor's rebuttal close in this case, starting at page 63 of the transcript. The prosecutor initially talks about that there was a fighting call, but then he says at the bottom of page 63, the officers arrived, talked to parties that were involved in the incident, and once those parties on the scene, and that's when Anthony Irvin began his disorderly conduct. The disorderly conduct, once Officer Hughes began investigating this incident, and there were other parties on the scene, that's when Mr. Irvin began his disorderly conduct. So it's not reliant upon any statement, even the ones that Mr. Irvin said, that he had been engaging in fighting prior to the officers arriving on scene. Instead, it all has to do with the 7 minutes in which Mr. Irvin was yelling at people on the street, approaching people, confronting people, walking up to a pickup truck and yelling at people, being warned by Officer McDowell repeatedly, just stop, calm down, I want to get your story. And eventually, I'm going to have to tase you, shock you with a taser, or I'm going to have to arrest you if you don't calm down, and finally, that's it, I'm going to arrest you. So it was for 7 minutes that Mr. Irvin engaged in this conduct. And concerning whether a police officer acting in the scope of their duties can be inconvenienced or annoyed or alarmed for the purposes of the disorderly conduct statute, they can. And that's referenced by this court in the State versus Seidel case, the State versus Kilby case, and also the Kirkpatrick case from the 11th District. And in this case, how these officers were inconvenienced was that they had to break away, first Officer McDowell and then Officer Hughes, away from finding out what the background was or investigating the call for which they had been summoned to the scene. And so they had to deal with Mr. Irvin, who would not stop being disruptive, yelling at people, making statements that the trial court perceived as being threatening to people for 7 minutes.
I want to go back to those cases you just cited from the 9th District. In Seidel, and I was the officer judge on that case, there was a nurse who testified that she was unduly delayed and annoyed by being spit on. Do we actually have a case where there isn't a complaining witness that isn't an officer saying that they have experienced undue delay, annoyance, alarm, whichever section of the disorderly conduct, whichever part of that is the subjective standard in the disorderly conduct statute?
Well,
Of the 3 cases you named, I know Seidel was a nurse, and I know she did testify, and that was part of the analysis.
I believe Kilby, which was from back in 1994, involved inconvenience to the officers involved, because in that case, Kilby, the officers are there at a store talking to the complaining witness, and Kilby returns to the scene and then tells officers, do you know who I am? He's a city councilman, and he disrupts the investigative process. And so that one was a case where the officers themselves were inconvenienced because it disrupted their ability to do their jobs.
So, but would that be more of an obstruction of official business rather than meeting the elements of disorderly conduct if you don't have a person who subjectively says they were annoyed or inconvenienced or alarmed?
It could be obstruction of official business, but remember also, you don't have to have direct evidence from somebody some civilian who says, I was inconvenienced, I was annoyed, I was alarmed. I mean, the point of salmon, even though it was under a different subsection of the code, is that that in that case, that court found that the circumstantial evidence, that there was circumstantial evidence that the people were themselves irate, that not only had they been, had there been a tendency for that defendant's behavior to cause somebody inconvenience, annoyance, alarm, but he actually did.
So to get this straight, you're saying if there's circumstantial evidence that someone was subjectively annoyed or alarmed, that's enough?
Correct.
Not an actual direct testimony from a witness who says these things?
That's correct, because circumstantial evidence, of course, bears the same weight as direct evidence. And you can take from the circumstances that were surrounding the incident to see whether somebody else, a bystander, for instance, was inconvenienced, annoyed, or alarmed. And given the yelling and screaming that was going on, regardless of who instigated it, okay, there were people in that neighborhood who Mr. Irvin was yelling at, who were yelling back at him. So clearly they were annoyed, in order to engage in that conduct themselves. So, but again, this is one of those cases where, Mr. Irvin for these 7 minutes engaged in all of this conduct, and not all of the bystanders who were around him were engaging back. Now, regarding Mr. Irvin's allegation that his mindset in this, that he was agitated, that he was annoyed, he was egged on, or that he was instigated by others, that's irrelevant to whether his conduct was turbulent or annoying or alarming to anyone else. So, it really doesn't matter. So it is another red herring. But based upon all of the evidence that is in the body-worn cameras of Mr. Irvin engaging in his conduct, that is overwhelming evidence of his guilt for this offense, regardless of anything the woman in red may or may not have said. Her statement, by the way, again, wasn't offered for its truth. So when it's not offered for its truth, because everything that he was charged on and convicted on was his own conduct in front of the police officers, then her statements are not offered for their truth, and not only are they not improper hearsay because they're not hearsay, they also, under the Smith versus Arizona case from the U.S. Supreme Court, can't defend the confrontation clause either. So unless there are any further questions from the court, again, the state would ask you to affirm. Thank you very much.
We have 2 minutes and 5 seconds.
Your Honor, as to the need for complainant's testimony about inconvenience, annoyance, or alarm, whether that can be proved circumstantially, I would obviously, it would be good for us if the rule this court announced was that you do need direct testimony of, but I don't think you need to get there. I don't think you necessarily say it can never be proved circumstantially. If, for instance, you had a case where the victim was on body camera crying or otherwise, clearly visibly affected. The Ori case that the state cites in its brief did involve an instance where there wasn't direct complainant testimony about their subjective mental state. That's from the 11th District. It's distinguishable on its facts, I think. The appellant was observed fighting with another individual. The patrons of the bar were in a general state of panic following the gunshot inside the establishment, and there was scattered fighting within the crowd. So, if you have those kinds of circumstantial facts, I would concede that you don't need direct proof from the person who is inconvenienced, annoyed, or alarmed. But we just don't have those facts here.
So if you see someone crying, how's that different than seeing people annoyed on a video with no sound?
I think it is different. I think waving arms isn't necessarily inconvenience, alarm, or annoyance. It could be indicative of anything. As to the remark that was made about it doesn't matter who instigates the yelling, I submit that it does. Under the plain terms of the statute, the prohibition is that no person shall recklessly cause inconvenience and so on. And so it does matter who is causing these reactions. And to the extent that the state has said the only conduct that matters in this case is what happens once, what you can see in the body camera footage post-arrival, I think the question then becomes, was the admission of that statement harmless beyond a reasonable doubt, and for the reasons I talked about, for the reasons we've outlined in our brief, I submit that the answer is no, and with that we'd ask you to reverse as we've asked. Thank you.
Thank you both for your presentations. The court will take this matter under advisement and issue a decision in due course. The clerk of courts will mail you a copy of the decision on the day it's released, and the opinions are posted on the Ohio Supreme Court website. Thank you again for your presentations. This court is now adjourned.